do you need an attorney, and how do you know when you really should get one, you need one?
If you find that you're losing a lot, but you're losing because you aren't able to tell your story to the court effectively, right? If you're
Okay.
having a difficult time doing that and getting shot down and not heard, it's probably more of a procedural issue or something going on rather than you losing for the merits,
Will
right?
a
And I think in those
judge
cases, you want an attorney.
will a judge ever feel sympathetic if you don't have an attorney, sympathetic more for you, especially if your partner, your other side does have an attorney, to which it's okay, I'm going to risk not having an attorney, but hopefully I get some sympathy? Or would a judge go, you should have got a lawyer. It's your kid. Why didn't you?
Well, as an attorney, I always want the judge to hold everybody to the same standard.
Yeah,
And
of course,
so
yeah.
I will say this. They have an obligation to hold somebody who is self-represented to the same standard as an attorney. So for example,
Okay.
if I have to file document
Hmm.
15 days prior, because that's what a court rule says, the other unrepresented person that doesn't know the court rule doesn't get away with not filing the court paperwork 15 days ahead. They're still held to the same legal standard. Where I do see judges being more flexible is when it comes to like hearsay objections, or you're not supposed to tell narratives when you're in court and testifying, but oftentimes they'll allow those kind of things to happen because it's very difficult to not give a narrative when you self-represent, but otherwise they are required to hold to the same
Okay.
standard. They're not allowed to give somebody that's self-representing an
That's
easier
fair.
time. Yeah.
So let's say we're going to court and we can't make an agreement. So we're going to have some argument. How do you prepare one of your clients?
I have three things that I tell people that are going into court, whether they have attorneys or they don't have attorneys. And that is that you want to treat it as a professional experience. That can mean you're on time, you dress intentionally, and you are treating it with the respect that it deserves when you have whether you like the court system or not, when you have
Hmm.
one human that is about to make a decision that is going to entirely affect the rest of your life, like a custody visitation schedule of your
Yeah.
children, treat it with the respect that whole situation requires. Being on time, presenting yourself correctly, and overall being professional. So that's the first one. The second is be prepared in that you've thought about what the hearing is for and you have put together an idea of what you want to say that specifically targets what the court is trying to hear. So, for example, a lot of people get confused and they'll go in and it'll be a child support hearing and they'll start talking about how they need to change custody because something happened. The
Hmm.
court isn't going to hear anything on child custody because that's not what the day is about. The day is about child support.
Hmm.
And the reason that's important is because you only get 5 minutes. So if you
Yeah.
spend 4.5 minutes on the wrong thing,
You're wasting time.
you're wasting time. You gotta stay on point. And that
Yeah.
is kind of to the last thing that I tell people, and that is you want to prepare your presentation to the court where first you acknowledge the importance of what is happening. So I understand that a relationship with both parents is really, really a good idea. You want to follow it up. So it's kind of like start with a compliment, right? Then the next thing you want to present is your issue. I understand that it's really important for our child to have a relationship with dad. My concern is that for the duration of and the history of our relationship, dad was a heavy drinker and would pass out drunk every single night, and I had to take care of the kids. And this behavior is continued because dad got a DUI last week. So I'm concerned about dad's drinking with the kids.
Perfect.
And then end it with what you want a court to do. Therefore, I would like the court to order a visitation schedule where our children can be with dad, but there's no alcohol 12 hours before dad's visit. There's no alcohol during the time that dad has the children. And if at any point at pickup or drop off, mom believes that dad is under the influence, she can demand a breathalyzer. Why does that work? Because you haven't said, oh, dad's such a horrible person and I can't stand him and he always drank while we were, and I had a parent. Don't complain. Nobody complains. You're acknowledging this important role. You're bringing up your issue, which is important, but you're providing the solution. You're giving the court exactly what you want them to do, and you're giving them the justification to order it. And if you do those three things, I think you've addressed everything that the court needs. You might still lose, but at least you've given the court what they need to even consider your point.
And you've made it easy for them. Easy, yes or no.
Silver platter.
Right. And so to which, again, they're looking, if you got a judge who's, man, I need more coffee to digest. It's complex. Oh, you made it real simple. I'm going with that guy or that woman because I understand that.
Right. Or maybe the other parent, maybe you're wrong. Maybe my silver platter is the wrong side, but other parent hasn't told them anything to say why I'm wrong, or has gotten so bogged down in feelings, emotions, and name calling that the court is like, I don't even know what's happening here. Okay, I'm going to go with mom, right?
Oh, so let's talk procedure. This is where I really am deer in the headlights